rise. The Universal Freedom of Expression Court is now in session. Honorable Judges Paolo Pinto de Albuquerque, Mabel Agaman, Netta Zemel, Nicholas Blake, and presiding with Judge Krangsak Kitichisari as president of the court. The current matter before the court is the case between Peeps and Scoops as applicants against the Federal Republic of Tertonia as respondents. Each side has 45 minutes to present their case, and first counsel for the applicants is requested to come forward.
Yes, you may start.
Mr. President, Your Excellencies, may it please this court. My name is Sean Au, and together with my co-counsel, Ms. Grace Goh, we appear on behalf of the applicants, Mr. Niam Peeps and Scoops. I will speak first for 22 minutes regarding the prosecution of Peeps under both the Online Dignity Protection Act, or the ODPA, and the Information Act, or the IA, namely issues 1A and 2A, as found at paragraph 14.3 of the facts. Ms. Goh will then address this court for a further 21 minutes on the prosecution of Scoops under both acts. We respectfully reserve 2 minutes for rebuttal. Your Excellencies, as a state party to the International Covenant on Civil and Political Rights, the Republic of Tertonia is obligated to protect its citizens' rights to the freedom of expression. In our present case, Tertonia has instead prosecuted my client under 2 different acts and sentenced him to 2 years imprisonment alongside a fine of $100,000, all for a single publication. Through its unnecessary prosecution and its harsh punishments, Tertonia has violated Peeps' right to the freedom of expression. Now, while my client's conduct may have been controversial, he was ultimately seeking recognition through the use of social media by posting something which he believed to be true and which needed to be told. And the European Court of Human Rights and the UN Human Rights Committee have both accepted that for a state to justify their prosecution and interference with a right's freedom to expression, they must satisfy.
Counsel, excuse me. The applicant claims the protection of freedom of expression. Which aspect in the facts do you claim are protected? Because we see that it is a news flash that was put forward, and we also see that there are various sources that have seemingly confirmed what you are putting forward. So could you explain which aspect of freedom of expression?
Certainly. Judge Zemel, we are asking this court to protect Peeps' right to the freedom of expression through both the publication of the photo and the caption which accompanied it. And in my submissions today, in showing that Tertonia had overreacted in its prosecution of Peeps, I will be making 3 submissions before this court. Firstly, that the prosecution was not provided by law. Secondly, that the prosecution was not in accordance with a pressing social need.
So are you maintaining it's the news that you were putting forward?
Judge Zemel,
Or the opinion?
it is both the post in its entirety, which includes the caption, the news, and the photo as well.
And the news are based in what facts?
Judge Zemel, we do acknowledge that the news has not been confirmed or denied. Now, clarification 29 shows
It goes
us.
a little bit beyond that, doesn't it? If we take your 2 submissions, generally speaking, it's a requirement of the second offence under the Information Act that the information is false. And therefore, it's not simply it hasn't been confirmed or denied, it has been to the satisfaction of the National Court that the allegation that the minister was having a sexual relationship with a terrorist, and in the course of that sexual relationship abused her public powers to offer visas to terrorists out of an affection, is a false statement.
Judge Blake, to clarify, the IA is not only concerned with the publication of false information, but false information which incites violence or hostility. And here,
I appreciate this part too. I was just picking you up on the fact that you were submitting to us, as I thought, that it hasn't been confirmed or denied, whether the allegations in the news flash were accurate or not. I think that's putting it a little inaccurately.
Judge Blake, this goes precisely towards our argument, in that the IA requires that the information published must be false and must incite hostility. But as can be seen from clarification 29, the Tertullian court themselves were unable to confirm the truth or the falsity of the underlying story, and yet they nevertheless prosecuted Pepys under both the ODPA and the IA. But if I may address each point in turn, firstly, our submissions. Thank you, Mr. President. Our first submission goes towards the prosecution of Pepys under the ODPA not being provided by law. And our arguments can be found at paragraph 6 of our written submissions. And our submission today is that the ODPA was not meant to apply to photoshopped intimate images. Now, under international law, a prosecution is justified only if individuals can reasonably foresee that their conduct would attract liability under that statute. Now, we note that the respondents at paragraphs 5 and 6 of their written submissions have argued that this requirement is fulfilled as the wording of the ODPA is sufficiently precise. Now, Your Excellencies, we do agree that the wording of the ODPA is sufficiently precise, but it is sufficiently precise to show that photoshopped images are not captured by the Act, and support for our position can be found when we adopt a textual interpretation of the Act. If I may refer this bench to paragraph 10.2 of the facts. There we can see section 1 of the ODPA, which reads that liability may be imposed on individuals if, and I may quote, who knowingly distribute an image of another person who is identifiable from the image itself and whose intimate parts are exposed. Now, Your Excellencies, on a plain reading of these words, we can see that the ODPA was only meant to apply to situations where the image, which is disseminated, depicts the actual intimate parts of that individual. Accordingly, it could not have reasonably been foreseen that the publication of a Photoshop nude image, as we are concerned with today, would attract liability under the ODPA, and such prosecution by Tertullian was an overreaction and was not prescribed by law.
Well, you're suggesting that on the strict construction of the criminal statute, your client wasn't guilty, but the National Court took the alternative view, it must have done to reach the conclusion it came, that the possessive word whose refers to the image, indeed, of Miss Kohler, rather than the genitals belonging to her, or the nipple, or whatever it was, the pubic hair. And as long as she is identified by the photograph and the other material appears to relate to the photograph, isn't that a legitimate construction behind the social purpose of this legislation, to protect women in particular from abusive posts?
Judge Blake, our position is that that is not a legitimate interpretation of the statute. For the European Court of Human Rights, in its 2015 decision of parent check in Switzerland, has stated that any expansion or application of a statute must be such that, if I may quote, a person can know from the wording of the relevant provision what acts and omissions will render him criminally liable. Now, Your Excellencies, we do acknowledge that Kohler should not be left wanting for recourse.
Counsel, excuse me, but do you not agree that parent check circumstances are very different from your case?
They certainly are, Judge Simbele, but we are seeking to rely on that proposition that this requirement of prescription by law is only satisfied where the application by the state of that statute is such that individuals can reasonably foresee it based on the plain wording. And while we acknowledge that Kohler should not be left wanting for recourse, if the state had deemed it necessary to prosecute Pepys, the ODPA was not the appropriate instrument to do so. But in yet another instance of overreaction, the state prosecuted my client under 2 acts even though there was no need to do so. And this brings me to my second submission on there being no pressing social need. Now, we note at the outset that Pepys was prosecuted under both the ODPA and the IA, and we propose to deal with each act in turn.
I have questions. In paragraph 6 of your written memorandum, you focus a lot on distinction between fabricated, and actual photos. And you try to explain that the fact that the law in question, penalize so-called the use of fabricated photos is against principle of legality or is too vague. But if you look at Article 9 of the 2001 Budapest Convention on Cybercrimes, prosecution can cover the issue of simulated, fake, or photos appearing to be child. So the fact that it's not actual photo doesn't mean that it's against the law or principle of legality. How would you explain that?
Mr. President, our position is that, as stated by the European Court of Human Rights in its 2011 decision of editorial board in Ukraine, is that this, apologies, this requirement is satisfied where individuals can reasonably foresee that their conduct would attract liability. And here, the question before this court is whether it was reasonably foreseeable that posting a Photoshop nude image would attract liability under the ODPA. And on a plain reading of the ODPA, this question must be answered in the negative. But even if Your Excellencies are not with us on this point, we note that this test is a conjunctive one, such that failure of any one limb must lead to the finding that there has been a violation of Article 19. And there is also a violation of Article 19, as there was no need
Counsel,
for...
you mentioned the Ukrainian case in the European Court, but in that case, the circumstances were again very different, because the journalist in that case could not possibly foresee, since the no regulation existed.
Certainly,
We have quite an extensive regulation in our case.
certainly, Judge Zimbabwe, but much like in that case, we are arguing before this court that there was no basis for Terturnia to prosecute PEEPs under the ODPA, as when we take a literal construction of the ODPA, it was only meant to apply to real images. But, Your Excellencies, if I may turn to my second submission on there being no pressing social need. Thank you. Now, first, turning to the prosecution under the ODPA, our arguments can be found at paragraphs 10 to 15 of our written submissions. And we note that the respondents have argued at paragraph 11 of their written submissions that this prosecution was to protect Kola's rights to privacy and reputation. And we do not dispute this, Your Excellencies. But at paragraph 13 of their written submissions, they have justified their prosecution of PEEPs under the ODPA solely on the basis of the doctrine of the margin of appreciation. But their submission is wrong on two reasons. Firstly, they fail to recognize that the United Nations Human Rights Committee, the chief interpretive body of the ICCPR, which we are concerned with today, has stated in General Comment 34 that this doctrine does not exist, for undue reliance on it would undermine the protection of human rights according to common standards. And secondly, even if we do accept that it exists, the margin of appreciation in and of itself is not a justification for a state's restriction on speech. Rather, states must adduce relevant and sufficient reasons as to why the restriction is necessitated before relying on the margin of appreciation. And here, while we do acknowledge that Kola was subject to harassment and threats, and we do not wish to downplay their severity, in assessing whether there is a need for Terturnia to prosecute PEEPs for its publication, the consequences to Kola must be balanced against the contribution to a public debate. As stated,
Well, what contribution to a public debate does a fake Photoshop image of a leading politician on a difficult brief of immigration make?
Judge Blake, if I may answer your question in two parts.
Please.
Firstly, this post contributed to a public debate as it depicted Kola alongside Pakta, the leader of a terrorist organization, and as can be seen from paragraphs 3.1 to 3.2, Pakta had been in hiding for some time to avoid arrest. Now secondly, my second point under that is that it also discussed Kola's suitability to hold office as the Minister of Immigration and also questioned the various...
Could you explain how the image that you posted actually relates to these 2 points of the alleged public interest that you claim?
Judge Milling, as can be seen from
Before
paragraph...
you answer that, is it public interest if you fabricate a story and then you post it and purport to be posting something journalistic when you know it is not? And you say that you are contributing to public debate?
If I may address Judge Agoyang's question before Judge Nabilis?
Yes.
Thank you. Now, firstly, to clarify, here, Pepys did not fabricate a story. As can be found at paragraph 12.3, he had found this photo online, and at paragraph 12.2, he used this to, and if I may quote, illustrate their relationship for my group's friends. And ultimately, he maintained a genuine belief in this story. And further, as earlier argued, clarification 29 shows us that the truth or the falsity of this underlying sex for visa story had yet to be determined even following trial. But with regard to the falsity of the post, which relates to Judge Blake's earlier question as well, while we do acknowledge that a post that is false is less likely to contribute to a public debate, as stated by the European Court in its decision of Stoll and Switzerland, that very court in its 2017 decision of Eigel, Einarsson, and Iceland stated that publications, even if they may be false, may nevertheless contribute to a public debate. Now, in that instance, it concerned a public figure who had the false allegation of rape made against him. Now, even though the allegation was false, the European Court of Human Rights nevertheless found that it could contribute to a public debate, as what the court was concerned with was not simply the veracity of the allegation, but the subject of the allegation being one which the public had an interest in knowing. Now, turning to our present facts, we are concerned with Kola, who is the Minister of Immigration and, as can be seen at paragraph 4.1 of the facts, a champion of Aquarian immigrants. Now, this allegation related to her being corrupt and her handing out 23 immigration visas to true religion terrorists. Now, even though the photo was false, Your Excellencies, we argue that it could contribute to a public debate, and the clearest indication of this can be seen at paragraph 9.3.
So fabricate a lie and then debate the consequences of the lie. Is that what you're telling us? Doesn't sound too attractive to me.
Judge Blake, we are not going so far as to argue that.
Well, aren't you? I think you are. But where do you stop short?
Judge Blake, if we may attempt to draw a line for this court. Here, Pepys was not fabricating a story.
Was he not?
Our position, Judge, again, is that he was not. Ajman, apologies, was that he was not. Now, he maintained his genuine belief in the story.
Well, what
How
we
could he
know-
have believed in it when he took the picture from a website with the caption, if Kola had a boyfriend, it would be this man, ha? How would you take that to mean that he actually believed that it was a proper story?
Your Excellencies, we know that the facts are silent as to his specific state of mind with regard to the authenticity of the photo. But ultimately, the burden was on the state to prove that he knew it to be false. And paragraph 12.3 shows us that no such finding
Where
was
do you
made.
get the standard for? The argument that it is for the state to prove that it is false. Could you refer to international standards?
Judge Simela, this relates to their prosecution of Pepys under the Information Act, which requires the information to be false.
But it was false.
Yes.
No, international standards, because if you are arguing that you were providing with this news flash, actually news about the corruption and about trading in the visas, where do you get the source of that information? And do you argue that the state has to prove where the source is for that information?
Judge Zimeli, to clarify, perhaps we were loose with our words. However, our position maintains that because this post contributed to a public debate, there was no need for Tertullian to prosecute Pepys. But even if Your Excellencies are not with me on this point, we also argue that there was no need to prosecute Pepys under the Information Act, as what is required for finding that a publication incited violence is that there was a likelihood that hostility would arise following the publication. And this was stated by the European Court of Human Rights in its 2015 decision of Parentcheck and Switzerland.
Right.
And there the
Yes. A likelihood that hostilities would arise. Wouldn't you think it's quite likely in a politically charged atmosphere between a neighbouring state and Tertonia, and we know that the politics of immigration often arises strong emotions, to accuse the Minister of Immigration of committing a criminal act of corruptly issuing visas to terrorists because of a terrorist lover, when the terrorist lover and the act itself are entirely unsubstantiated hypotheses, might lead to a breakdown in social relations in a charged society?
Judge Blake, we do note that here we are concerned with a charged society, and this is precisely the argument which the respondents have put forth in their written submissions. However, Your Excellencies, context alone is insufficient to justify a prosecution, And this was stated in the case by the African Court on Human and People's Rights in the 2017 decision of Ingabire and Rwanda, where at paragraph 159 it states that putting severe restrictions such as criminal punishments merely on the basis of context would create an atmosphere where citizens cannot enjoy the right to freedom of expression. And there, it was set against the backdrop of the Rwandan genocide. And despite such high tensions in that context, it was nevertheless found that the context alone was insufficient to justify a prosecution of the individual. But in light of the remaining time, if I may turn to my third submission on proportionality, it is that the sentences of 2 years imprisonment under the ODPA, as well as the $100,000 fine under the IA, were disproportionate. Now, firstly, in assessing the proportionality of a sentence, the state must adopt the least restrictive measure to achieve the legitimate aim pursued. And here, imprisonment is rarely an appropriate penalty for attacks on privacy and reputation. This was stated by the United Nations Human Rights Committee in General Comment 34, as well as the European Court of Human Rights in its decision of Cumpana and Romania. Now there they stated that imprisonment should be reserved for exceptional circumstances, and they list, for example, where it relates to terrorist propaganda, child pornography, or hate speech. But here the ODPA is not concerned with any of those categories. As such, Your Excellencies, we urge this court to find that imprisonment should not be the first port of call, as it would have a chilling effect on speech. Now, the European Court of Human Rights in Cumpana and Romania found that where such criminal sanctions exist, it would dissuade members of the public from commenting on matters of general interest for fear that they would be risking criminal liability or sanctions. But even if this court is minded to find the imprisonment is appropriate, this sentence and the duration of 2 years is manifestly excessive. As in the case of Cumpana, Romania, previously cited, the European Court of Human Rights found that a 7-month imprisonment sentence for a mere allegation of corruption within the Romanian government was found, and if I may quote, to be undoubtedly very severe. Now, Your Excellencies, imposing a 2-year imprisonment for an allegation of corruption against Kola must be found to equally be manifestly excessive. But in addition to this 2-year imprisonment sentence, the state further imposed a $100,000 fine on my client under the IA. And Your Excellencies, even if this court were to find that a criminal sanction of a fine is appropriate, the amount is manifestly excessive as well, as in the case of Mobala in France, the European Court of Human Rights found that a mere $10,000 fine for hate speech was proportionate. Yet, Tertullian has far exceeded this by imposing a $100,000 fine. Now, I know that my time has expired, Your Excellencies, but the clearest indication of overreaction by the state can also be seen in the obligations it imposed on Scoops, a mere social media platform, a point which my co-counsel will now address before this court. Now, unless I may be of any further assistance.
Thank you.
Thank you, and may it please this court.
You may proceed.
Mr. President, Your Excellencies, may it please this court. As earlier introduced, my name is Grace Goh, and I also appear for the applicant, Scoops. I will be addressing the issues of the prosecution of Scoops under the ODPA and the IA, and these are issues 1B and 2B found at paragraph 14.3 of the facts. Your Excellencies, the state of Teutonia has overreacted not only in prosecuting Peeps, an individual, but also in pursuing liability on Scoops, a mere social media intermediary under both the ODPA and the IA. And to demonstrate this before this court, I will make 2 submissions. First, that there was no pressing social need to prosecute Scoops under both the ODPA and the IA. And second, that the sentences imposed on Scoops were manifestly disproportionate. On the first submission of a pressing social need, whether there is a pressing social need to prosecute Scoops boils down to 2 questions posed before this court. First, are the obligations imposed on Scoops under the ODP and the IA onerous? And second, should social media intermediaries as private entities be charged with the responsibility to independently censor the speech that is uploaded on their platforms? On the first question of the onerous obligations under the ODPA and the IA, I first turn to the ODPA at paragraph 10.2.1 of the facts. And there it states that the social media intermediary is held liable where they knowingly distribute a nude image of a person where they know the person has not given consent. And crucially, again, at section 3B of the same statute, contained at paragraph 10.2.3 of the facts, it also provides for a defense of public interest, which allows the intermediary to escape liability if the disclosure falls within the meaning of that section. But crucially, Your Excellencies, despite the fact that there is the exception for public interest, the ODPA does not allow for the defense of expeditious removal.
Counsel, could you remind us what is an international standard with respect to the responsibility of intermediaries? Could you refer us to some relevant texts? and
Of course,
case
Judge
law?
Zemelli. While there might not be case law that has laid down the exact parameters, we will look to the 2017 Joint Declaration on the Freedom of Expression, where they have recognized broad categories of blatantly illegal speech for which intermediaries must act to remove content even without user complaints. And as my co-counsel has alluded to, these categories relate to child pornography, terrorist propaganda, and hate speech. But we would say that those categories can be distinguished from the present facts, as in this case, it does not fall within those established categories. It is possibly illegal content with the elements of public interest. And we submit that where this determination...
So you're referring only to this joint declaration. What legal status does it have?
Judge Zemelli, we do acknowledge that it is a mere declaration. It does not have the effect of a treaty. But there's also case law that goes to the nature of the liability that may be imposed on intermediaries. For example, in the case of Delphi and Estonia, held by the European Court of Human Rights in 2015, as well as the case of MTE
And what
in
did Delphi say?
And Delphi has laid out certain factors to determine the liability of intermediaries. For example, their nature, the reach of the publication, the identification of whether
But the principle is there is certain responsibility that goes with.
Yes, Judge Zemelli, the applicant is certainly not making the case before this court that the social media intermediaries have a blank check to do anything they wish, but merely that where the state chooses to interfere with their freedom of expression, it must be done justifiably, and this has not been made out in this case.
So you don't quarrel with the statement of principles in the Strasbourg court in MT, for example?
We do not, Judge Blake.
No, thank you.
And you're arguing that the intermediary has the freedom of expression.
Yes, we do recognize that intermediaries do have the freedom to
And in the
disseminate.
facts of the case, what aspect of the freedom of expression, how would you define it exactly?
The freedom of expression in this case would be the dissemination of information, given that Peeps chose to upload his post on Scoop's online platform and they hosted it and they allowed it to be viewed by their users, and has been as recognized rather in the cases of Delphi and Estonia and MTE in Hungary. The right to the freedom of expression under Article 19 of the ICCPR extends to organizations where they disseminate information, and this is the meaning of the freedom of expression for Scoops in this case. Returning to the obligations under the ODPA does not contain the defense of expeditious removal, despite also the exception of public interest, and the applicant submits that in effect, what Teutonia is asking the intermediary to do is to investigate if the disclosure has been made in the public interest, but yet it has not provided the reasonable time to make such a determination. And at clarification number 21, or rather, paragraph 13.2.3 of the facts, it is stated that the point of liability in which Teutonia found Scoops to be guilty under the ODPA was on May 2nd, 7 p.m., and this was the time that Cola had submitted a complaint form on Scoops' platform. And we say that...
But could you explain why exactly Scoops did not react more swiftly? I mean, what was in this information that did not ring the alarm bells with the intermediary?
Judge Zemelli, we would point to the fact that the complaint that Cola chose to make was not via her official account nor her personal account, as stated at clarification number 21. It was made anonymously via an open source complaint form, and since liability under the ODPA turns on the person allegedly depicted in the photo not giving consent, for an anonymous reporting form to be the point in which Teutonia chooses to impose liability on Scoops for having knowledge, we say that this is onerous under the meaning of the statute.
I thought you knew it's from her office that made the complaint.
The-
Doesn't sound entirely anonymous to me.
To clarify, Judge Blake, if I may turn this court to clarification number 21.
Yes?
It is stated that Cola used a regular, free-access, non-Scoops user form available on the website to make a report. Perhaps Judge Blake refers to the receipt of a defamation letter on the part of Cola's office, and this will move to the obligations under the Information Act.
May I say this? According to the facts, a third party, sorry, this thing worked by algorithms, right? And also by human review, right? So at some point they must have seen it. A third party saw it at 5 p.m. That's XYZ, saw it at 5 p.m. and dissociated themselves from it. And the office of Cola also came out with a statement. And so even though the trial court did not talk about the 5 p.m. thing, but limited itself to the 7 p.m. thing, don't you believe that it had enough time, since there was human review, for them to have noticed that there was this thing that was wrong, if a third party thought it was bad enough to have dissociated themselves from it?
So I think I would like to add on this point. It seems that here the scope seems to be acting in the manner in which it consciously disregards the so-called abuse that have already been committed against Cola. So it fits the prescription under Section 1A of the OBPA. How would you respond to that?
Your Excellencies have raised two concerns, and first with regard to the elements of human review as well as the algorithm, we do acknowledge that Scoops has this technical ability, but on the facts of this case, given that the depiction possibly may have included the elements of public interest, and Scoops would have needed time to make the assessment of whether or not it would have fallen within the exception 3B as provided for at paragraph 10.2.3 of the facts. Therefore, Teutonia to choose to impose liability simply at the moment where Cola submitted an anonymous complaint form sets a dangerous precedent that Teutonia requires intermediaries to act merely on anonymous complaints, even where possibly they may not be merited or completely unfounded on the facts. And with regard to the knowing or conscious disregard that may possibly be interpreted by this court, we would urge this court to find that Scoops has not been guilty of this, given that the complaint form was anonymous, and we did in fact choose to take action by asking Cola to fill up the second factor of authentication in providing her details. But she chose not to do so, and despite this, when Scoops eventually received the threat of a defamation letter, we acted expeditiously within 50 hours to remove all 21,000 shares of the post from the platform.
But would the Scoops actually accept that this news flash and the photo contain the content that is illegal and that should have been taken down in accordance with not only the domestic law but international standards?
Judge Zimeli, we would say that possibly when they saw the post with the element of human review, that it may have fallen within the meaning of the ODPA, given that they would not have known it was Photoshopped, but they should have been given the time to make the determination if possibly they could avail themselves of the defense of public interest, and this time was not given to them by Teutonia.
Don't you think 50 hours was a long time, given that an hour after it was posted, there were 10,000 shares?
Judge Agiman, this actually turns to the... Agiman, my apologies, Agiman.
It's a difficult name.
Judge Agiman, turning to the second prosecution under the Information Act, which actually concerns whether or not 50 hours was a reasonable time, we note that the state of Teutonia has found that this was unreasonable, and the respondents themselves, at paragraph 75 of their written submissions, have stated that because of the high traffic, the virality, as well as the sheer notoriety of the post, that this means that Scoops would have known of the illegality under the meaning of the Information Act. But under the European Court of Human Rights case in 2008 of Vachna and Hungary at paragraph 57, the court clearly stated that mere public outcry is an insufficient reason for the state to act to interfere with the freedom of expression, as the right should not be subject to a heckler's veto.
Was the case relevant for the responsibility of intermediaries?
We do acknowledge that that case concerned an individual who wore a star on her chest, and as a result there was a public outcry. But we are relying on this case merely that where there is a public reaction, it is insufficient for the respondent to merely rely on this particular fact, as this simply focuses on the mere reactions following the uploading of the post. But it completely sidesteps the inquiry of whether or not the intermediary knows, in fact, that the information is false. We also turn to the fact that at paragraph 77 of their written submissions, the respondents have sought to rely on COLA's denial, as well as the fact that XYZ News came forward to dissociate themselves from the post. But with respect, Your Excellencies, neither of these facts take the respondent's case very far, as this also subordinates the actual determination of falsity for the mere reactions following the uploading of the post. First, with regard to XYZ News dissociation, what this dissociation goes as far as to say is that the person who uploaded the post was not sanctioned nor employed by XYZ News, the actual company, but does not make a definitive pronouncement on the veracity of the post. And similarly, as for COLA's office making a public statement, we cannot take her statement at face value, given that first, she is the very person depicted within the post, and she has a stake within this particular allegation. And the fact is, as my co-counsel has argued at clarification number 29, even at the level of the Teutonia domestic court, the truth of the allegation has not been proven. All the more, the social media intermediary cannot be charged with the responsibility of making this determination of falsity or whether or not it fell afoul of the ODPA.
So you are saying that intermediaries cannot be responsible for carrying fake news?
Well, Judge Zimeli, when it comes to fake news that does fall within the categories recognized as blatantly illegal, where it shades into child pornography or the incitement of violence, then we would say that social media intermediaries must be held liable. But in this case, where it falls within false information that may in fact is difficult for the social media to determine, that they should not be given liability as a default position by the state. And this in fact brings me to the second question before this court on whether or not there's a pressing social need. The question being whether or not social media intermediaries as private entities should be charged with the responsibility of independently censoring the speech on their platforms. And we submit that the answer before this court to this question must necessarily be no. We note at the outset that from paragraphs 26 to 28 of their written submissions, the respondents have stated that intermediaries should bear the brunt of liability for all illegal content because they rapidly disseminate information, or also because the information uploaded on the internet becomes permanent after it is uploaded. But Your Excellencies, these reasons
Counsel,
only...
coming back to your point that you could not have immediately seen that the content of this post is fake or in any way violating the basic principles or human rights, do you consider that you have a post which in fact carries a photo of a naked woman, that does not fall under any of the criteria for in fact demanding action upon you?
We do acknowledge
And
that...
in fact a public figure?
We do acknowledge that certainly we do not want public figures to be wanting for recourse. And we're also not asking this court to make a statement that we are not protecting the rights of women with regard to allowing their intimate parts to be exposed. But what we are saying is that yes, nudity is offensive and certainly defamatory. But first, there are other forms of recourse. In this case, COLA in fact chose to possibly pursue a defamation suit in the Teutonian domestic court. We say that for the state to act using its criminal organ to prosecute on behalf of this government official is an unjustified interference.
So you complain about the act itself, that you say that they should never have passed this act with the consequence of criminal liability for ISPs.
Judge Blake, we are not, we to clarify, Judge Blake,
Yes.
we would say that the enactment of the ODPA and the IA is appropriate, but when it comes to the proportionate response and the choice of this particular prosecution, it has been disproportionate.
Well, I thought you were saying that. I'm not sure that that's what the case law of the human rights bodies says. They look at the pressing social need for the state to pass legislation that penalises things. And then, if there is a good case to pass the legislation, they rely upon the states to decide whether anybody is guilty or not guilty. I thought your point was that there was no defence of takedown for the obscenity or act, but there is a defence of knowledge. And if you didn't know that it was not intimate, that gives you some certain amount of time to consider your position. And whereas there is there not, under the Information Act, an express defence of expeditious takedown? So that submission only goes to the first. But I think you've been focusing upon prosecutions rather than the legislation itself.
Judge Blake, to clarify, the applicant is not challenging for the prosecution of scoops, the limb of the prescription by law. we are certainly accepting that in and of itself, the ODPA and the IA, in its enactment, allows groups to reasonably foresee
But
its
you just
liability.
don't like internet service providers facing prosecution.
We're not asking for the court to make a broad brush or blanket statement that in all cases, internet service providers are allowed to escape liability.
So some internet service providers on some occasions can be prosecuted penally.
We are certainly not making a case for selective prosecution, but simply where in this case there is a contextual and difficult determination on the falsity of the post, that the intermediate...
Why was it difficult? Because, back to how it works by human review, right? So at some point, especially after 5 p.m. when XYZ came out to say that they were not involved in it, and the caption said XYZ newsflash, couldn't you have known that it was false?
We would say, Judge Ajimang, that even when it comes to
You
the...
got it right.
Thank you. I'm glad that I finally got
You're
it right.
making progress, definitely.
When it comes to the dissociation by XYZ News, we do acknowledge that certainly this may go to denying certain credibility given that an established news source has come forward to deny it. But by nature of these serious allegations involving politicians that are put on the internet, often they do not go through established sources, as can be seen by many leaks involving well-known politicians. In 2017, the French presidential election, there were certain allegations and documents that were leaked on the internet concerning then-candidate President Emmanuel Macron. And crucially, Your Excellencies, that was not an established source. And also, the veracity of those allegations were never proven.
The President would have
was
taken
it-
down within a
it
matter
was-
of hours. He acted very promptly. And here, we've got the 4 things, haven't we?
50 hours.
We've got the 50 hours from the formal defamation action, and before that you'd had the note from her office, and before that she'd issued a public statement on the press. Presumably your clients are able to
And
read
XYZ
press
had
reports,
complained.
and then as Judge Agman has pointed out, there was also the contribution from the reputable newspaper.
Judge Blake, we would go to the fact that social media intermediaries as private entities do lack the legitimacy as well as the authority to make independent determinations on when they should censor the speech. They cannot be asked to take the different facts, for example, the denial by COLA, or the differing claims on the veracity of the post as conclusive determinations of whether or not they should remove the post, given that they have not created it.
But surely such images are violent and discriminatory against women.
We do acknowledge and fully empathize with the fact that women do face disproportionately the fact that when it comes to nude images, there's a form of reputational damage as well as an invasion of privacy that's involved in such cases.
So what were you doing in the 50 hours when you had the complaint, as you were agonizing over the truth or otherwise of this?
Trying to raise more money.
First, to answer Judge Blake's question on the 50 hours, it is unclear on the facts. But we would say that in the 50 hours, it is a reasonable time to remove all 21,000 shares of the post. So look to an example of other intermediaries, for example, Facebook. Upon receiving a complaint, they
No,
take...
that example you shouldn't look at.
Well, apart from the example of Facebook, perhaps I could point to other legislation in Germany, for example, which allows for a total of 7 days for the intermediary to investigate and eventually remove only possibly illegal content. And with regard to the commercial interest, we do acknowledge that Scoops is a money-making platform. But the fact that it allows money to be made on the post does not mean that it intentionally or insidiously allowed the post to remain simply to increase its profit revenue. On the facts of this case, given the difficult determination, we are simply making the case that the proper body to make the determination is that of a judicial or executive order. In the 2011 United Nations Special Rapporteur Report, it has been recognized that intermediaries should only be given liability where they fail to comply with such a judicial or executive order. And this is the position that has been adopted, for example, in Chile, Portugal, and Spain. And on the facts of this case, no judicial order has been given, and we submit that this is, in fact, no pressing social need
And
to
how does
prosecute.
the view of the Special Rapporteur looks from the point of view of the cases you cited, notably the Strasbourg case law?
We do acknowledge that in those cases there was no judicial or executive order. The intermediary chose on their own initiative to remove the post. But that will go to the intermediary's individual choice to do so. But we are saying that international law should not create a blanket obligation for intermediaries to be held liable.
Even when it is a post which incites racial discrimination and hatred?
Your Excellency, as far as I know that my time has expired, if I might,
I allow you 2 minutes to answer the
And
question.
answer questions of the court.
of course. Judge Demeli, we do acknowledge that where it clearly does go to inciting violence and hatred, that certainly the intermediary must be
So your
liable.
position is contradictory.
To clarify, Judge Demeli, we would say first that the caption and the post in this case does not fall within the category of hate speech or incitement to violence. And where it does, then certainly we would acknowledge that the intermediary would be held liable. But short of this standard, there should not be default intermediary liability in this case. But in light of my 2 minutes that has been granted by Mr. President, I will move quickly to my second submission on proportionality and summarize it before this court. Your Excellencies, the issue of proportionality goes to accepting the least intrusive measure that is proportionate to the prosecution. And this has been accepted by the respondents themselves at paragraph 72, where they accept that the standard for proportionality is for the state to adopt the least intrusive measure possible. And in this case, the imposition of direct criminal liability is inappropriate, given that this is the criminal sanction of the state, and it goes to a a chilling effect on the freedom of expression. We would point to the fact that a total of $300,000 was in fact imposed on Scoops as a social media intermediary. In the case of MTE in Hungary at paragraph 82, a mere civil fine of $260 was already considered to have a chilling effect on the freedom of expression. And we know that the bite of a civil fine is in its quantum, and the bite of a criminal sanction is in the state expressing its disapprobation for the intermediary in this case. On the facts of this case, we have both a large quantum and the expression of disapprobation by the state. And we say that in totality, this makes the interference by Teutonia on Scoop's freedom of expression unjustified. Your Excellencies, this brings me to the end of my submissions, and unless I may be of any further assistance, thank you and may it please this court.
Thank you. Now invite the respondents to proceed. You may start.
President Kitichay Sari, Your Excellencies Pinto de Albuquerque, Adjamang, Zimeli, and Blake, good afternoon and may it please the court. My name is Tess Tan, first agent for the respondent, the state of Teutonia. With me is my co-agent, Mr. Mark Badayos, and our off-counsel, Ms. Stephanie Alea. Together, we respectfully enter our appearance before the Universal Court of Free Expression, pleading in behalf of the state. As first agent, I shall speak first for 22 minutes to address the first two prayers for relief. These concern the prosecution of the applicants Niam Peeps and Scoops under the Online Dignity Protection Act. Mr. Badayos will speak next for 21 minutes to address the prosecution of the applicants under the Information Act or the IA. In consequence, Your Excellencies, we shall be reserving 2 minutes for rebuttal if necessary. Unless there be preliminary inquiries as to the material facts, I shall now begin with my submissions. Thank you, Your Excellencies. Mr. President, Your Excellencies, the case before this honorable court today has been downplayed by the applicant. Continuously throughout both submissions, they have said that this is an overreaction on the part of the state. Allow respondent to clarify the narrative. Your Excellencies, this case before the honorable court is a case involving an attention-seeking xenophobe who stole a woman's image and made it appear to be a matter of breaking news. He started a national conspiracy theory which led to the loss of innocent lives and called it free speech. He misled the entire country and made it appear to be a matter of public interest. Your Excellencies, while the freedom of expression is a fundamental right, it is not a license to strip anyone of their dignity, nor does it provide any levity to disrupt public order. I shall have two submissions this morning, Your Excellencies. First, respondent submits that the prosecution of Peeps under the Online Dignity Protection Act is valid as it is both provided for by law and is necessary and proportional under the circumstances. Secondly, I shall make submissions regarding Scoop's prosecution that it was necessary and proportionate under the circumstances. To directly address the submissions made by both applicants, I shall make my submissions in the same order as far as practicable. Turning first to the matter of PEEP's prosecution under the ODPA, or the Online Dignity Protection Act. Your Excellencies, first, the first agent for the applicant has made a case that the prosecution was not provided for by law because the restriction was not sufficiently precise as to be foreseeable. Your Excellencies, respondent rejects this as a...
Counsel, can I interrupt you before you go into this argument? Do you actually agree with the applicants that what we are dealing with is the case of freedom of expression? And what kind of freedom of expression? Are we talking about provision of information or something else?
Your Excellencies, we submit that this is a matter of freedom of expression as much as this is a matter of the question of the rule of law, which protects such expression. While the applicants have made it appear to be about political expression, we submit that this is hate speech dressed up as political speech and should therefore be restricted under Article 19 of the ICCPR.
And what about Article 20?
Certainly, Your Excellency. Returning, Your Excellencies, to the matter of the restriction being provided for by law. While we note, Your Excellencies, that the applicants contested that the law was not sufficiently precise as to be foreseeable, we reject this as a matter of law and as a matter of fact. As a matter of law, Your Excellencies, the European Court of Human Rights in paragraph 57 of Biermann versus Germany, as well as paragraph 26 of Edition Plons versus France, has categorically stated that laws may be couched in broad terms so as to be elastic enough to adapt to changing circumstances, particularly in the field of communication. As a matter of fact, Your Excellencies, as can be gleaned in paragraph 10.2 of the case problem, the ODPA specifically prohibits the knowing distribution of the intimate images of a person where there is a substantial and unjustified risk that the person did not consent to the disclosure. Now, the strongest argument that the applicants have...
Counsel, could you explain to me the relationship between the Online Dignity Protection Act that you are right now explaining and Article 20, paragraph 2? Sort of where do you see the links? You were just saying that under Article 20 of ICCPR, you consider that that is hate speech. Could you sort of draw the links between the domestic provision and the ICCPR?
Certainly, Your Excellencies. In fact, just to clarify the stance of the respondent, the claim that this is hate speech inciting to violence will fall under the restriction provided for by the Information Act. As to the Online Dignity Protection Act, Your Excellencies, this goes to a matter of public order which penalizes non-consensual pornography, which respondents take
And
as a
which
form...
international standard that relates to?
I'm sorry, Your Excellency?
Which international standard does it relate to, this domestic provision?
Your Excellencies, we note that there is state practice, which is an indication that there is customary international law to this respect. Customary international law, Your Excellencies, is a source of an international
Well, we know.
obligation.
You can proceed.
Thank you, Your Excellency. Returning then, Your Excellencies, to the strongest argument that the applicants
But you
have...
did not formulate the rule.
Certainly, Your Excellency.
What's the formulation of the rule, whatever the source, customary or treaty? What is the rule of international law that you are claiming that you are implementing through the Online Dignity Protection Act?
We note, Your Excellencies, that the freedom of expression may be restricted if there is a need to ensure public order as well as protect reputational rights.
And the government of Teutonia says it's restricting freedom of expression by the Online Dignity Act because
non-consensual pornography, Your Excellency, is a form of image-based sexual abuse. We note, Your Excellencies, that this goes to the matter of the necessity of prosecuting PEEPs. While we note that the applicants have tried to characterize this restriction as only a matter to protect the reputation of others, respondent submits that this is in fact a matter of public order. Your Excellencies, allow us to substantiate. Non-consensual pornography is a form of image-based sexual abuse. This is the unanimous opinion of scholars in the matter, particularly Professors Daniel Citron and Marianne Franks. As a form of sexual abuse, Your Excellencies, while the harm is primarily suffered by one person, because it is a matter of sexual abuse, the entire community is affected as a whole. This is precisely why child pornography... Yes, Your
right,
Excellency?
that's why you promote legislation. I think that's a sufficient answer to my question, at least. Perhaps you can just, whilst you're on this topic, then address the point which I imagine you're about to come to, which is the way that the Republic legislated, made it a necessity that the individual's private parts are being displayed, where here it said that the private parts that were on display were photoshopped from an anonymous body.
Certainly, Your Excellency, that brings the applicant to the strongest case, rather the respondent, to the strongest case that the applicants have mounted against it, in that the nature of the photo itself is photoshopped. Respondent, however, submits, Your Excellencies, that the ODPA provides for the coverage of sexualized images, and for good reason. First, Your Excellencies, as noted by Justice Kennedy of the Supreme Court of the United States in Ashcroft versus Free Speech Coalition, the harm that is derived from an image, rather the harm of an image is derived not from the means of its production, but the content in the image. In fact, Your Excellencies, with the advent of artificial intelligence, as well as morphing technology that have been removed from the recesses of the dark web and have entered mainstream cyber ecosystem, it is now indistinguishable. The fake pornography as well as real pornography is now virtually indistinguishable, as can be gleaned, in fact, from the factual patterns, Your Excellencies, particularly paragraphs.
May I intervene? Is this not the application by analogy of a criminal provision, what you're doing? Because in fact, the provision, if you read it, literally talks about the image of a person and the intimate parts of this person. And what you're saying is that a photoshopped image, which in fact is a combination of two different persons, or the images of two different persons, can also be included within the scope of this criminal provision. So you are extending, by interpretation, the scope of the provision. Isn't this prohibited by the principle of legality in criminal law? I know that we are not here standing as a fourth instance court, but when the interpretation of national law is arbitrary, we do have a saying.
Certainly, Your Excellency. Allow us to clarify. It is the respondent's submission that ODPA covers sexualized or sexually manipulated images from the wording of the law itself. As can be gleaned by the definition of the word image, Your Excellencies, it includes other reproductions. This should mean, Your Excellencies, the coverage not only of real photographs, but including morphed photographs, which through the advent of technological advances has made it...
You are maybe aware of Council of Europe standards, for instance, treaty standards, which refer exactly to this equation between real images and fake images, but it is indeed provided by these treaties, namely the Convention on Child Pornography, that a photoshopped image can be prosecuted and should be prosecuted when this is foreseen by national law, by domestic law, not by creation of the courts. So what you're saying is that by a creation of creative interpretation of statute, you can equate a true image to a photoshopped, a creation of a photoshopped image.
Au contraire, Your Excellencies, we note from paragraph 2.2 of the facts that Tertonia is a civil law country. What is the meaning? What is the significance of this fact? This means, Your Excellencies, that as a civil law country, Tertonia employs the black letter approach in determining and applying...
That plays against you.
Au contraire, Your Excellencies, under the principle or elementary fundamental rule in statutory construction, ube nos distinguere nec nos distinguit debemos, when the law does not distinguish, one must not make a distinction. Therefore, Your Excellencies, respondent submits that because the wording of the ODPA does not make a distinction between real and fake images, then it covers, and it should cover, sexualized...
This principle is a part of the principle of analogy. You are extended. It applies to civil law, not to criminal law.
On that note, Your Excellencies, if this honorable court were not to take the argument of the applicants, rather the respondents, that the ODPA covers sexualized manipulated images, Respondent still submits, however, Your Excellencies, that it was foreseeable for PEEPs to determine that the posting of the image would be covered by the ODPA and for good reasons. As can be seen in paragraph 10.1 of the facts, Your Excellencies, the ODPA was created to address the rising crimes of revenge pornography, particularly after the death of 2 Tertonian teenagers. The death of these Tertonian teenagers will show that the legislative history was created not merely to address revenge pornography, but the psychological and professional harms that may be caused because of non-consensually sharing intimate images. Your Excellencies, turning then to the matter of the necessity and proportionality of PEEP's prosecution. Your Excellencies, under this submission...
What is the necessity of this intervention, a criminal law intervention, when there was already online this image? It was already available. There was already a knowledge of this image. What is the necessity? And on top of that, there was no reaction, criminal law reaction against this first publisher. Why to choose these people? The second one, and again with two pronged reaction, not only with a fine but also with imprisonment.
Your Excellency, allow us to make a sharp distinction between the posting of the image on the Turton Power website versus the posting of the image on Scoops. The posting of the image on the Turton Power website, Your Excellency, was made under an obscure corner of the web, particularly catering to members of...
The web is available everywhere, so it's not an argument to say that there is an obscure corner of the web. It's if you want, you can find it, like PEEPs found it.
Certainly, Your Excellency, we do note that because of the internet and its advances, there is a contextual and temporal dislocation to speech. However, Your Excellencies, the posting of PEEPs on Scoops will show that this, in fact, was a calculated falsity. Allow us to clarify the narrative, and this goes to the earlier question of Judge Adjamang regarding why would a false image be made to contribute to a public debate. Your Excellencies, we note from paragraph 7.1 of the facts that there was premeditation on the part of PEEPs. He created the false news outlet account a day before he made the post. In fact, during the trial, Your Excellencies, we note that he grabbed the photo from the Turton Power website, even if the post was accompanied by a caption conclusively showing that the image was false. Despite knowing that the image was false, he repackaged it to appear as true, using the false news outlet account, which gave it a badge of legitimacy. He posted it on Scoops, the most popular social media platform, which gave the post an aggravating circumstance of social media. According to the Venice Commission report of 2016, this aggravating circumstance is due to the amplifying nature of the internet. Therefore, Your Excellencies, the post of PEEPs should not fall within the disclosure made in the public interest exception. Disclosures made in the public interest presupposes the existence of a truth that has been unearthed or an honest belief of that truth. No such honest belief of such truth may be found here. Now, Your Excellencies, there was an argument earlier that Cola is a public minister, and we note that as a public official, she enjoys a reduced expectation of privacy. However, Your Excellencies, even the European Court of Human Rights, in paragraph 32 of its decision in Rojovi Pantar versus Czech Republic, has noted that when there is a distortion of truth attended by bad faith, that already escapes the acceptable levels of criticism. And therefore, Your Excellencies, we also note the decision of the European Court of Human Rights in paragraph 53 of Standard Verlags versus Austria, a case that is very intimately connected with this one, as it involved the First Lady of Austria, who was allegedly having intimate affairs with other leading politicians. It bears to note that the First Lady of Austria in this case was also the head of a department in the Ministry for Foreign Affairs, which also called into question the policies of the Foreign Ministry, Your Excellencies. And in this particular case...
Counsel, could you... That's all fine. Now you are evidently putting a major restriction on the freedom of expression of PEEPs in this case. And you mentioned that the legitimate aim that you are pursuing with this kind of legislation is public order.
Yes, Your Excellency.
Could you elaborate on the legitimate aim? How do you understand it? Because what you're talking about right now, it sounds to me like public morals. And if you would use Article 19 of the ICCPR, paragraph 3, because it is only these legitimate aims that you would be entitled to pursue with this legislation.
Certainly, Your Excellency. When we speak of public order, respondent understands that usually it is connected with the peace and security of the state. However, Your Excellencies, respondent submits that there should be an evolving understanding of what constitutes public order when lives are at stake. In fact, Your Excellencies,
Was there incitement to violence here?
What lives?
Your Excellencies, allow us to substantiate. With regards to the question of which lives were at stake, Your Excellencies, we put forward the cases of suicides because of non-consensual intimate images being posted online. As to the matter
reason for registration.
As to the matter of incitement, Your Excellencies, we do note that there was incitement in this case, which will be elaborated by our second agent. But in a nutshell, Your Excellencies, when we talk about incitement, we not only look into the context, but also the content of the post, which our second agent will again elaborate on. But Your Excellency, yes,
Could
Your
you just
Excellency.
help me between these two? And I appreciate you're dealing with the first prosecutions. What was the worst conduct of PEEPS? Incitement to disorder under the Information Act, or the conduct under the earlier act?
Your Excellencies, respectfully, respondent would not like to weigh which would be heavier because Your Excellency.
There's a point here to be made, is that you have punished with imprisonment mere distribution, and incitement to violence you punish with a fine. And by the way, with the same fine that you apply to a corporation, to a moral
Well,
person.
no doubt your colleague will deal with the second part of that
Certainly
question,
not.
but I think the first is
all-
definitely for you.
This is all about proportionality of the reaction of the state.
Certainly, Your Excellencies, and allow us to respond on two levels. First, Your Excellencies, the reason that the respondent will not make a distinction on whether what is the heavier crime, incitement or dignity of women, is because, Your Excellencies, respondent submits that protection of women should be taken as a primary role of the state under the doctrine of parens patriae, particularly because women are a vulnerable group in society. We are speaking of a vulnerable individual here who has suffered online and offline harassments after particularly the posting of this image on Scoops. Secondly, Your Excellencies, the reason that respondent continues to submit that the Online Dignity Protection Act is proportionate under the circumstances is because ultimately, Your Excellencies, the professional and personal carnage suffered by Cola, added with the considerations that 2 Aquarian immigrants died because of the post, made this a matter of the highest order. Therefore, Your Excellencies, the online...
There was
You
no
did not
finding of
reply-
fact. There was no finding of fact by the trial court that the 2 people died as a result of the post.
Your Excellencies, we note that there
Or
was...
that Kola was affected professionally. She resigned without public statement.
Your Excellencies, we note that Cola did not make a public statement before she resigned. However, this is the very same thing that happens to victims of traditional revenge pornography. They are forced out of their jobs. They are forced outside their traditional homes because of shame, victim blaming that is present here, Your Excellencies. Your Excellencies, I note my time if I can just summarize the argument regarding the proportionality of this conduct. In fact, Your Excellencies, the Online Dignity Protection Act is not the only revenge porn law which has imposed penalties of this magnitude. Kevin Bollard, for example, was imposed with 18 years of imprisonment because of non-consensual pornography. Hunter Moore was sanctioned to 2.5 years where no person died. In fact, Your Excellencies, the United Kingdom has imposed a 3-year term of sentence on a 14-year-old boy.
But you claim that that's an international standard?
Certainly not, Your Excellency. However, when we appreciate proportionality, we look into materials that speak of the same offense. And so respondent submits that
How considerable your coverage is? How many states did you look at?
Your Excellency, I note my time if I may just answer your question. We note Thank you, Mr. President. Your Excellency's respondent is prepared to say that there are at least 7 countries in the world which have enacted
Out of
revenge.
almost 200.
Yes, Your
Thank
Excellency.
you, fine, thank you.
Mr. President, Your Excellencies, I thank you for your time and indulgence. May it please the court.
Thank you. Counsel, you may proceed. Quiet, please. You may proceed.
Mr. President, Your Excellencies, good afternoon, and may it please the Court. My name is Mark Lawrence Badayas, Second Agent for the Respondent, the State of Tertonia. With this Court's permission, I shall use 21 minutes of its time to forward the third and fourth submissions of the Respondent concerning the prosecution of peeps and scoops under the Information Act of 2006, or IA. Your Excellencies, turning first to the Respondent's third submission, or with respect to the prosecution of peeps under the IA. Applicants earlier contested the validity of PEEP's prosecution and argued that it failed the test of legality and the test of necessity. Respondent submits to the contrary that PEEP's prosecution under the IA satisfies both tests. Allow me, Your Excellencies, to substantiate on both tests. First, under the test of legality. Under this test, Your Excellencies, applicants put forward 2 points of contention. First, applicants argued that Section 1B of IA creates a chilling effect as it covers an overly broad spectrum of false and misleading statements. Respondent rejects this argument, however, as a matter of law and as a matter of fact. As a matter of law, Your Excellencies, Respondent is willing to concede and acknowledge that penalizing expressions on the basis of falsity alone may violate international human rights standards. Respondent submits, however, that when expressions of falsity amount to incitement, a restriction thereto is valid, in deference to Article 20, Paragraph 2 of ICCPR.
Could you define the incitement exactly here in the circumstances of the case? What has the peeps incited? Who?
Definitely, Your Excellency, and that now leads me to the test of necessity. While the applicants have put forward in their submissions that the context alone should not be the only determination as to whether or not it amounts to incitement, neither should it be limited, Your Excellencies, to the content of the expression, and in this case, we refer to PEEP's post. Applicants put forward the case of Solas and Another versus France, Your Excellencies, where the European Court of Human Rights explained that in order to analyze whether incitement exists, due regard must be given to the content and within the lens or through the lens upon which such post was made. In the present case, Your Excellencies, allow us to draw the picture of the context upon which PEEP's post was made. PEEP's post was made in the context of a febrile environment, which is characterized by the generalized anger against Aquarian immigrants, allegedly because they were stealing jobs from Tertonians and allegedly because they diluted the culture of Tertonians. Furthermore, his post was made in the context of the fear of extremism and the rise of true religion, rather, Your Excellencies.
So in other words, you're saying that this post incited the hatred against the neighboring country's population or the immigrant population coming into the country.
Yes, Your Excellency. And while we acknowledge that there is no express reference to Aquarians on the post of PEEPs, as can be seen in paragraph 8.3 of the case problem, respondent rather submits, however, Your Excellencies, that because of the context upon which PEEP's post was made, it created a direct association between true religion and Aquarians, especially understanding that it was to the mind of the Tertonians, and as can be seen in the case problem, that true religion has gained popularity among young Aquarian immigrants, and understanding that it has spread widespread terror in different institutions in a neighboring country. In the present case, Your Excellencies, because of the association and because the 23 members of True Religion, which was unnamed, Your Excellencies, in the post of PEEPs, it positively stimulated into the minds of every Tertonian that because they were unnamed, every single Aquarian that they see may possibly be part of these 23 members who were given visas and are given access into the borders of Tertonia. Furthermore, Your Excellencies, we also take into consideration the principle of accusation in mirror, which is a hallmark in incitement cases. This principle, Your Excellencies, provides that inciting expressions often assert that there is a serious danger to the lives and safety and security of the audience, Your Excellencies, because of the victim group, and therefore positively inciting the victim group, Your Excellencies. And no better example is for this particular principle, Your Excellencies, is no better example than the post of Peeps. Because if I may quote Your Excellencies in paragraph 8.3 of the case problem, Peeps' post characterized the true religion members, the 23 of them, which is directly associated, Your Excellencies, to the Aquarians as quote-unquote truly terrifying individuals who will use any means of violence to enforce their religion. This positively incited Tertonians, Your Excellencies, positively incited Tertonians to go and take lawless actions, Your Excellencies, as in fact this may be proven by the violent protests which occurred on May 4 and May 5, leading to the death of 2 Aquarians. Your Excellencies, indeed, the evil lies in the calculated subtlety of Peeps' post, as can be seen in paragraph 8.3 of the case problem. Turning back, Your Excellencies, to the test of legality, applicants contested the foreseeability of Peeps' prosecution and argued that Section 1B of IA creates a chilling effect as it covers an overly broad spectrum of false and misleading statements. What the respondent would wish to highlight, however, is that Section 1B of IA does not penalize expressions on the basis of falsity alone. Rather, it narrows down penalty to expressions of falsity that may amount to incitement, as can be seen in as can be seen in Section 1B of the IA, and if I may quote, it uses the phrase.
If there was such a serious problem with incitement to violence, why was not there a reaction by the state to the first publication?
Your Excellency,
Why was not there a reaction to the first publication? Because this was not the first publication.
Your Excellency, if you're referring to the posting of the image of Peeps, rather Cola and Parka on the discussion thread of Turton Power website, Your Excellencies, that image has to be differentiated, has to be distinguished, Your Excellencies, in its entirety from when it was posted in Scoops. Because when it was posted on the discussion thread, the caption of the image was, quote unquote, if Cola had a boyfriend, it would be this guy. Definitely, Your Excellencies, that would not amount to incitement. However, when it was transposed to the online environment of Scoops, Your Excellencies, the image, which purported to be true, Your Excellencies, came with a caption alleging that 23 members.
So freedom of expression here is dependent. So you are claiming that the first one is protected by freedom of expression, right?
Yes, Your
The second one not.
Yes, Your Excellency.
And so everything here depends on what text is added to the image.
Your Excellency, particularly because Peeps was prosecuted for an inciting expression, and therefore we have to look into the content or the content of the expression, Your
So
Excellency.
the image is not relevant. So the fact that there was an image, a sexualized image, is not relevant.
It is relevant, Your Excellencies, as to the mind of Peeps, Your Excellencies, because he believed this to be true as...
We don't know what was in his mind.
Your
It's
Excellencies,
not a fact.
we understand, Your Excellency. However, respondent...
May do know what was in his mind because the court concluded that he must have known that it was not a relationship between Kohler and the terrorist man, because that's what it said. And I think your point is, in answer to the judge's questions, is that the first post, apart from where it was posted, was simply to do with an abusive comment about the kind of partner she might have. The second point is related to corrupt activities of a relationship with a terrorist undermining the Tortonian immigration system. It seems to me that the second is a great deal more serious in terms of public order than the first.
Your Excellency, even taking the applicant's case to its highest, and even considering that, Your Excellencies, that the image may not have played any significance or relevance with respect to the discussion of incitement, Your Excellencies, the content of the expression or the caption that came along with the image, even taking it in isolation with the image, may already amount to incitement, especially when put against the context upon which the expression was made. But respondent submits that the posting of the image along with the caption may have been an intent of Peeps to close any gap on the minds of Tertonians, Your Excellencies, regarding the truth or falsity of the sex for visa scandal, with all the more reason.
Did it incite anybody to violence?
Sorry, Your Excellency.
Did it incite anybody to violence?
It did, Your Excellency.
Was there a finding of fact from the trial court?
There was a finding of conclusion of law, Your Excellencies, that Peeps' prosecution, and he was in fact convicted with inciting to violence. Furthermore, Your Excellencies, we put forward.
as if there was an incitement to violence. What did they say? Because you made a statement, and I was waiting for you to correct yourself, that 2 people were killed because of that.
Yes, Your Excellency. Although there was no finding, Your Excellency, that the death of 2 Aquarian immigrants by the domestic court of Tertonia, that it would be connected or directly attributed to the post of peeps. It is respondent's submission that it must be directly attributed to the post of peeps, Your Excellencies, because the proximity of peeps post, Your Excellencies, on May 2 and the violent protests on May 4 and May 5, where the deaths of 2 Aquarians immigrants occurred, Your Excellencies.
But there had always been protests. And previously, there had been a protest and somebody had actually been, had tried to assault Kola and was prosecuted for it.
The problem, however, Your Excellencies, is that there must be a distinction between the protests that occurred before the post and the protests that occurred after the post. The case problem characterizes the protest that occurred after the post as the largest protest outside Kola's office. Furthermore, before the post, the case problem does not provide for any death of any Aquarian immigrant within the borders of Tertonia, as opposed to after the post, Your Excellencies, the protests that occurred on May 4 and May 5, in fact, led to the deaths of 2 Aquarian immigrants. And it is for this reason, Your Excellencies, that respondent submits that peeps post does amount to incitement, and therefore it is a valid restriction to freedom of expression. Now, applicants in their earlier submissions argued that the fine of $100,000 is disproportionate, Your Excellencies. We, however, reject this argument as a matter of law and as a matter of fact. Your Excellencies, respondent submits that in fact criminal prosecution of inciting expressions is supported by law and state practice. As a matter of law, Your Excellencies, Article 20 of ICCPR, paragraph 2, in fact, provides that, well, it's not really criminalizations, Your Excellencies. However, Article 2 of ICCPR provides that states must adopt measures, Your Excellencies, which are effective and necessary to protect individuals from their right to life and from any physical danger or physical threat to their right to life. We, in fact, rely
Do
on...
you have an authority to quote on this?
We, in fact...
Apart from your interpretation of Article 20?
Yes, Your Excellency. We rely, in fact, on the case of Kontrova versus Slovakia, Your Excellencies, and in Kal versus Turkey, where the court noted that in order to ensure and secure public order...
Wait a minute. Are you talking about international covenant or are you talking about the European Convention?
We are talking about pronouncements of the of international human rights tribunals, Your Excellencies, that relates to the necessity and effectivity of domestic measures that address inciting expressions. Your Excellencies, international human rights tribunals, as relied by in the cases of Kontrova versus Slovakia and in Kal versus Turkey, in order to ensure public order.
You started your answer by reference to Article 20 of the ICCPR, if I heard correctly. And then you moved on to the case law of the European Convention on Human Rights. Article 20 of the ICCPR is rather distinct. Such an article does not exist in the European Convention, so that's why I'm not quite sure how are you making your argument.
Your Excellency, we understand, and allow us to clarify, Your Excellencies. Respondent submits, however, that with respect to freedom of expression under Article 19 of ICCPR and Article 10 of the European Convention on Human Rights, the provision under the ECHR, Your Excellencies, is almost replicated, and therefore it provides for a restriction on the basis of public order, Your Excellencies.
Okay, proceed. That's fine.
Thank you, Your Excellencies.
Yes, but I have a question regarding the point raised by my learned colleague. You look at Article 20 of ICPR, and then you transpose into jurisprudence of European Court of Human Rights. But this is quite risky because not many states in the world share the same moral standard as European Court of Human Rights and in the EU. So my point is, it strikes me that you look at the facts, the cases. Kola herself have not brought any legal action, say defamation or libel, against the party concerned, and then states step in. The question is, are these laws necessary in democratic society at all?
It is indeed necessary in a democratic society, Your Excellencies. In fact, member states of the Council of Europe impose prison sentences ranging from 1 to 10 years in order to address the distribution of inciting expressions. And we further note, Your Excellencies, that in this present case, there are two aggravating circumstances that has been noted by the 2016 report of the Venice Commission with respect to inciting expressions. Number one, Your Excellencies, the use of social media platforms, which they have characterized as a most powerful and virulent platform in order to incite, Your Excellencies, and have direct link to real-world violence.
The Council of Europe never talked about incitement to damage to national unity. This is absolutely out of our thoughts.
Your Excellency, while we understand that Section 1, Paragraph B concerns damage to national unity, that would rather go to the question on the foreseeability of PEEP's prosecution. And in this case, applicants did not contend the foreseeability of PEEP's prosecution on the basis of the wordings of the phrase, quote unquote, intent to incite civil unrest, hatred, and damage to national unity. Respondent therefore submits, Your Excellencies, that PEEP's prosecution under the IA satisfies the test of legality and the test of necessity. Turning now, Your Excellencies, to the prosecution of scoops under the IA. Applicants contested that Scoop's prosecution was not foreseeable, Your Excellencies. Respondent, however, rejects this argument as a matter of law and as a matter of fact. As a matter of law, Your Excellencies, in the case of Delphi versus Estonia, the court ruled that, or the court anchored the foreseeability of intermediary liability on the fact that these entities exist for an economic purpose, and therefore they are undertaking a professional, in a professional undertaking. And as professionals, the court characterized that they are used to exercise a high degree of caution in their undertakings and the risks entailed therein. In the present case, Your Excellencies, the case problem provides that Scoops in fact created the influencer score in order for readers to keep creating compelling content and for readers to keep sharing them, Your Excellencies.
Counsel, what's your position? Where is the freedom of expression of Scopes? How do you define that?
Respondent submits, Your Excellencies, that it is with respect to its right to disseminate information as an intermediary, Your Excellencies, and allow the democratization of expressions of individuals on the ground.
So it's perfectly fine if there are all these possibilities. You were just counting to multiply the information.
I'm sorry, Your Excellency.
You were arguing that on this platform there is a possibility to multiply.
That is correct, Your Excellency.
It's perfect in terms of the provision of information. It's a very good thing for democracy.
We agree, Your Excellency. Respondent submits, Your Excellencies, in fact, that the proportionality of the prosecution and the fine imposed on PEEPs satisfies the test of proportionality. And this is where we use the standards laid down by this court, by the European Court of Human Rights in the cases of Delphi, MTE versus Hungary, and PIL versus Sweden. And that, in those cases,
But how do you explain the necessity in a democratic society of this prosecution?
It is necessary, Your Excellencies, to prosecute Scoops in this particular case. Number one, because it is the most effective point of control, especially with respect to expressions that are harmful in the online environment, Your Excellencies. And furthermore, necessary because we have to rely on the standards laid down by the European Court of Human Rights in the cases of MTE versus Hungary and PIL versus Sweden. In those cases, Your Excellencies, the courts look at the nature of the online environment, the nature of the content of the expression involved, and the measures taken by the intermediary in order to prevent or remove the
But are
unlawful
you not
expression.
making Scoops as a kind of a censor of the information?
Definitely not, Your Excellency. What the respondent submits before this honorable court is that there was not enough measures taken by Scoops in order to remove the content of PEEPs, which, by the way, resulted to not only a violation on the dignity and reputation of COLA, but even to the death of 2 Aquarian immigrants. It actually incited violence in the state of Teutonia.
Can you explain why you prosecuted PEEPs for incitement to violence and Scoops for a different offense? Why not the same offense imputed to these people, to the moral person, since it's about the same facts?
Your Excellency, the reason why the respondent or the state of Tertonia has prosecuted Peeps and Scoops, I
For
note my
different-
time.
For different offenses?
Mhm.
Yep.
Yes, Your Excellency. It's precise for the matter that Peeps post may fall under the limb of incitement, and on the alternative, it may also fall on the limb of distributing false information that violates reputational rights, as can be seen in Section 1, Paragraph A of the Information Act, Your Excellencies.
So why
That
did they have
goes
the
also-
same,
So just lady first.
same punishment? Why were they given the same punishment?
Your Excellency.
Scoops has earned $100 million last year from its activities, right? So why the same punishment?
Your Excellency, this is understanding the fact that Peeps was the primary publisher of the information that indeed incited violence, while Scoops may only be considered as a secondary publisher, Your Excellencies, relying on the case of Duffy versus Google, Your Excellencies.
It was not the primary publisher.
Sorry, Your Excellency.
Peeps was not the primary publisher.
If I may just,
Yes, you have 2 minutes.
Peeps was indeed, Your Excellencies, the primary publisher in this case, because although he got the image from the discussion thread of the Turton Power, Your Excellencies, he repackaged the image to appear that it was true, took out the caption from that discussion thread and replaced it with another caption that amounted to an inciting expression, Your Excellencies, and indeed resulted to violence in the state of Tertonia. Mr. President, Your Excellencies, thank you for your time and indulgence, and may it please the court.
Thank you very much. You may be seated. Yeah, rebuttal. So the applicant would like to rebut? Yes. Please proceed. You may start.
Mr. President, Your Excellencies, we have 3 points in rebuttal. Firstly, we note that the respondents did not justify the prosecution of Scoops under the ODPA, but in also asking this court to find that there was also a violation of Article 19 through its prosecution of Scoops under the IA. Here, the respondents have simply relied on the facts that Scoops is a commercial entity. However, Your Excellencies, such broad justifications for liability are insufficient to justify criminal prosecution. On the second point, earlier on the prosecution of Peeps under the IA for inciting violence, Judge Agimang questioned on the link between the post and the violence, and it was rightly pointed out by this bench that there was no finding of fact under the domestic court that there was a link and that there were already existing protests. Rather, what international courts are to look at is at the content of the post and the likelihood that hostility would arise from the publication. And here, even if we accept that we do not always need an express reference to violence, at minimum, what is required is coded language as observed by the Council of Europe in the 2015 General Policy Recommendation on Combating Hate Speech. Not only is there no coded language, but there is no express references to queerance. Now, in light of the fact that there is no such link and the content is not likely to result in violence, the state cannot justify their prosecution of Peeps under the IA. Now, on our last point, this relates to the proportionality of the sentence, towards which Judge Albuquerque and Judge Blake earlier queried the respondents on. And that relates to the fact that Tertonia prosecuted and sentenced Peeps to $100,000 under the IA, the same fine it levied on Scoops. Now, Your Excellencies, we note here, and the fact that on top of that, there was a 2-year imprisonment under the ODPA, even though imprisonment and criminal sanctions should not be appropriate remedies for mere attacks on privacy and reputation. I note that my time has expired, and we urge this court to find that the prosecution of both Scoops and Peeps has been a violation of Article 19, unless I may be of any further assistance to this bench. Thank you, and that concludes the case for the applicants.
Thank you. The respondent.
Your Excellencies, good afternoon once again. 3 points of rebuttal coming from the respondent to address the rebuttals by the applicant. As to the liability of Scoops, because of lack of material time, the respondent was not able to present its case. However, it is found in the written pleadings of the respondent. The liability of Scoops is not based merely because of it is a commercial entity, but because it had editorial control over the subject because of the choice of the algorithm and human reviewers. Further, Your Excellencies, it was a continued question of the bench why it took Scoops 50 hours to remove the post, and the reason is that there is a commercial interest in keeping this post online. As found by the London School of Economics Media Policy Project, each impression would earn an intermediary an average of $7.19. Turning then, Your Excellencies, to the matter of the lack of causal link, Your Excellencies, respondent rejects this as a matter of law and as a matter of fact. As a matter of law, Your Excellencies, incitement is an inchoate crime. It may take on sophisticated forms through coded language. This was the finding of the UNHRC as well as the European Court of Human Rights in a number of cases, Forson versus France, Garaudi versus France, Mugesera versus Canada, in which case, Your Excellencies, as a matter of fact, coded language here came from the direct association of acquiring immigrants to the 23 unnamed terrorists belonging to certain powers, rather through religion. And lastly, on the proportionality of imposing the sanction, again, the applicant has characterized the ODPA as a matter of protecting reputational right. However, Your Excellencies, the ODPA is a matter protecting public order, which is considered to be a time when criminalization is effective because of the deterrent effect of criminalization, as well as the attachment of the proper level of social condemnation. Your Excellencies, it has been a marathon, it has been an honor. Thank you, and may it please the court.
Thank you so much.
The judges will now deliberate upon the outcome of the case. Everyone is requested to stay in the courtroom for a few minutes, whilst the judges are now requested to leave the courtroom. After the deliberation, the judges will be providing their comments.